This is a joint special session of the Board of Zoning Appeals and the Monroe County Commissioners to discuss a federal judge's decision in Geft Outdoor LLC versus Monroe County, Indiana, and Monroe County Board of Zoning Appeals. And I think I would suggest that the BZA open its meeting and the commissioners open their meeting, and then we can proceed with any questions from those bodies or open it up to the public for questions about this matter. And we've had a proposed response to the lawsuit that we've discussed in an executive session. And anybody that would want to, any of the board members who would care to make a motion on that proposed response could do so after discussion, and we could get a decision one way or the other.
Well, I'll go ahead and call to order the Board of Commissioners for this joint meeting with the Monroe County Board of Zoning Appeals. It is August 23rd, 2021, and all three commissioners are present.
And I will call to order the joint meeting with the county commissioners, August 23rd, 2021 for this special session. And it looks like we have all the board members. Is that correct?
Vicki Sorensen is currently logging on, Mary Beth, but it's you, Skip Daly, Bernie Garitas, and Margaret Clements at the moment. So you do have a quorum.
We do have a quorum. All right, thank you.
No. Mr. Schilling, would you like to go ahead and explain this for the public? Is there anything else you wanted to add?
Well, I would say that we are here to just discussing a federal court decision in the case of Geft versus Monroe County. Geft had filed for use variances and digital sign variances with the BZA. The BZA rejected those variances, and Geft sued the county in federal court, claiming that the denial violated its First Amendment rights on the grounds that the state mandated variance criteria are too vague for First Amendment purposes. Geft also attacked some of the exceptions that we have set forth in our sign ordinance from the permit requirements. And the Court of Appeals found that two of those exceptions were content-based and thus not supported by a strict scrutiny analysis, and struck those exceptions down, even though those exceptions did not apply to Geft's case. We have the judge has concluded that the county's off-premise sign regulations are constitutional, and therefore Geft is not entitled to an approval to erect its off-premise sign or digital sign. But because of the decision that portions of the county's ordinance were unconstitutional, the court has set this for a damages hearing in October. But has also before then ordered that a settlement conference take place on August 30th before a federal magistrate. And one of the purposes of this meeting is to consider a proposed response to the case. The federal magistrate has requested or ordered the county to respond by today with a settlement offer. So we're here to see if we can obtain authority to make it that
recording
offer.
In progress.
And the offer is a offer of judgment under trial or Civil Procedure Rule 68 in the amount of $100 plus attorney's fees and costs as a judgment to resolve every claim raised by Geft in its lawsuit, whether expressly discussed and decided by the judge or not. The parties have discussed the strategy relating to this offer in executive session, and are free to discuss it in front of the public now, and accept questions from the public.
Somebody on the Board of Commissioners wish to make a motion? And we can open it up for discussion and public comment.
Sure. I move to offer a settlement of $100 plus costs and attorney's fees to resolve all claims made by Gift Outdoor LLC versus Monroe County, Indiana, and the Monroe County Board of Zoning Appeals.
Second.
No,
Okay, we have a motion and we have a second. Would the BZA like to make a motion?
okay. Anybody want to do that? Okay. All right, I'll move that we offer a settlement of $100 to Gift plus attorney fees and plus the attorney fees and cost. And I'm sorry, I'm not very good at this. In order to help me out, somebody, please.
In order to resolve
In
each of the claims raised by Gift in its complaint.
Yes, in order to resolve each of the claims raised by Gift in its complaint. Thank you, Dave. I'm sorry. I totally was. All right.
And I second.
Thank you, Vicki. Are there any questions? Discussion?
Looks like Bernie has his hand raised.
Bernie, you're muted.
Yeah, thank you, Mary Beth. So my question is, if the BZA motion fails or the combined, if the motion fails to settle, or if it is approved, does the insurance company still ultimately decide? Or if we go ahead and vote to settle, is the insurance company out of it because they've already agreed with this settlement?
This is Karen Pollock. The insurance company has authorized the proposal, which is the $100 plus reasonable attorney fees and costs. If that is not approved by the BZA and or the county, then it will proceed to the settlement conference on August 30th, at which the insurance company will offer settlement at its discretion. It may choose to increase its offer. It may choose not to.
Any further questions?
Any questions from the Board of Commissioners? Okay. How about I open this up to public comment? Is there anybody from the public who wishes to make a comment on this item up for consideration? Just raise your hand on the Zoom screen. I do not see any public comment. We ready for a roll call vote?
It's that way.
All right, Mr. Schilling, would you call the roll for the Board of Commissioners on this item?
President Thomas,
Yes.
Vice President Jones,
Yes.
Commissioner Githens,
Yes.
motion carries 3-0.
Hey, Larry, you want to call the roll for the board? The BZA? You're muted, Larry.
And the vote is to approve a settlement offer, an offer of judgment in the amount of $100 plus costs pursuant to the federal rules of procedure. And vote in favor is a vote to authorize the attorney for the county in the federal case to make this offer of judgment. Bernie Garitas,
No.
Vicki Sorensen,
Yes.
Margaret Clemens,
No.
Skip Daly,
Yay.
and Mary Beth Skip Marchek.
Yes.
Okay, the motion is approved by a 3-2 vote.
Thank you. I would note that I just received an email response from Dirk Stahl, the president of the Indiana State Bar Association Land Use Section. I will forward that email to each of you. And he notes that the city of Evansville is involved in a similar lawsuit with GEFT. And the attorney general is thinking about becoming involved in the case because it does challenge the variance criteria, which Mr. Stahl believes, as we do, that we have no authority to alter. So I'll shoot that to you, and we'll be having discussions with him shortly.
Thank you. I don't believe we have any other business. Is that correct, Mr. Schilling? Mr.
That is
Wilson?
correct.
Okay. So I'm going to go ahead and adjourn the meeting of the Board of Commissioners.
And I will adjourn the meeting of the Board of Zoning Appeals. Thank you, everyone.
Thanks,
Thanks,
everyone.
Thanks.
Good evening.